On March 8th, 2024, a family in Naples, Florida, heard a loud crash inside their home.
A mysterious object falls from the sky. You can hear the impact when it crashes into a home.
Something had punched through the roof, gone through the ceiling, through the floor, and stopped somewhere inside the house. The son was home. He was not hurt, but the damage was real. When NASA analyzed the recovered object, it confirmed the object was a stanchion from ISS flight support equipment, hardware used to mount batteries on a cargo pallet that was jettisoned from the International Space Station. The hardware was expected to burn up during re-entry. A piece survived. Now, a family had a hole in their house, a repair bill, and a question that sounds like something from a movie. When space breaks your house, who actually pays for that? Let's map this out, because the answer is not one thing. It depends on whose object fell, what your policy says, and which path the money has to travel before anyone writes a check. The damage in this kind of scenario is real, and it can be layered. There is the physical structure: roof, ceiling, floor. There is personal property inside the home that might be damaged. There may be temporary housing costs if the home is not safe to stay in. And in the Otero family's case, according to their law firm, the claim they filed also included non-insured property damage, business interruption, emotional and mental anguish, and third-party assistance costs. The repair itself may be the smallest part of the total bill. So let's talk through the 4 possible payment paths. This is generally the first practical call in a situation like this, because it is the fastest route to getting the structure repaired. The Insurance Information Institute says standard homeowners policies commonly include coverage for falling objects, and notes that satellites, space debris, meteors, and asteroids are among the falling object types that may be relevant. But that is a general principle, not a guarantee. The actual answer depends on the policy wording, whether a relevant exclusion applies, the deductible, and the coverage limits. What homeowners coverage might include: repair to the structure, damage to personal property inside the home, and additional living expenses if the home becomes uninhabitable. What it might not include: the deductible, costs above the policy limit, business losses if the home is also used for work, emotional distress, or pre-existing damage. So the insurer may pay for the roof and the interior damage. That does not mean the total bill disappears. And here is something that may surprise people. The insurer may also file its own claim against the party responsible for the debris, trying to recover what it paid. That is called subrogation. In the Otero case, according to the family's law firm, the homeowner's insurance carrier submitted a simultaneous subrogation claim alongside the family's claim against NASA. Whether your policy actually responds depends on the specific cause of loss, the policy's language, and how the insurer interprets the event. Homeowners insurance varies by state and by company. If the object is confirmed as U.S. government hardware, there is a formal route to seek compensation from the federal government. The U.S. Department of Justice says that Standard Form 95 is used to present claims against the United States for property damage, injury, or death allegedly caused by the negligent or wrongful act or omission of a federal employee acting within the scope of their employment. The claim must be presented to the appropriate federal agency and must state a specific dollar amount. The Otero family's law firm said that on May 22nd, 2024, a claim was submitted to NASA seeking recovery for the family's damages. This is not the same as filing a lawsuit. It is an administrative claim. The agency reviews it. Whether compensation follows depends on what is legally established, not simply on the object being identified. What is still unclear from the available sources is the final public outcome of the Otero claim. Later legal and professional profile sources reference settlement discussions, but no official NASA settlement statement appeared in the confirmed research sources. So the safer way to frame this is, the family filed a claim, the claim established a real process, and the outcome of that process may influence how future space debris compensation works. Not all space debris belongs to NASA or a foreign government. Some of it may come from a private company's rocket, capsule, or satellite. In May 2024, NASA confirmed that pieces of debris found in the mountains of North Carolina came from SpaceX Crew Dragon hardware that had re-entered the atmosphere. Federal regulations under 14 CFR Part 440 require commercial space launch and re-entry licensees to demonstrate financial responsibility, which may include liability or property insurance, based on the maximum probable loss connected to the licensed activity. If a private company's debris damages your property, the company's insurance or financial reserves may be relevant, but coverage and liability would depend on what caused the debris, whether it was connected to a licensed activity, what the company's policy covers, and how responsibility is established. This path looks very different from the NASA government path, and the answer would depend heavily on the specific company, the specific debris, and the specific circumstances. This is where the story gets genuinely unusual. The 1972 Liability Convention, established through the United Nations, says that a launching state is absolutely liable for damage caused by its space object on the surface of the Earth or to aircraft in flight. It defines space object to include component parts. Absolute liability on the surface of the Earth means the launching state may be liable regardless of fault. The best real-world precedent for this is Cosmos 954. In 1978, a Soviet nuclear-powered satellite re-entered and scattered radioactive debris over Canadian territory. Canada presented a claim against the USSR. A 1981 protocol documents that the USSR paid Canada $3 million Canadian in full and final settlement. But here is the twist: the treaty does not advertise. The Liability Convention describes a state-to-state and diplomatic process. A private homeowner generally cannot file their own direct claim under the treaty, as if it were a standard consumer process. The claim travels through governments, through diplomatic channels. And there is another complication. Article VAD of the Liability Convention says the convention does not apply to damage caused by a launching state space object to its own nationals. So if US government debris damages a US citizen's home, which is exactly what happened in Florida, the treaty path that sounds like the clean answer may not be the direct route. The domestic government claim route may matter more. What exactly the right path looks like for a US homeowner hit by US government debris versus foreign debris versus private company debris involves layers of law that would depend on the facts of each case. Here is the decision tree based on what the research supports. First, identify the object. Before anyone can determine who might be responsible, the debris needs to be confirmed. In Florida, NASA did this analysis at Kennedy Space Center. Second, if you own the property, your homeowner's insurance may be the first practical call for structural repairs. But expect the deductible, check the exclusions, and understand that some categories of loss may not be covered. Third, if the debris was confirmed US government hardware, a formal government claim route may exist, but it is not an automatic check, and some categories of claim damage may be disputed. Fourth, if the debris came from a private space company, the company's financial responsibility framework and insurance may matter, but the path is different from the government claim route. Fifth, if the debris came from a foreign launching state, the US government may be able to pursue compensation through international channels under the Liability Convention, but that process is generally not a direct consumer claim. Sixth, some costs may remain disputed regardless of path. Emotional distress, business interruption, and uninsured losses are harder to establish than a roof repair invoice. The weirdest part of this story is not that space junk can hit a house. It is that the bill may have to travel through home insurance law, federal claims, commercial space liability rules, and international space treaties before anyone knows who really pays. And even then, the answer may be different for every scenario. This video is for educational and entertainment purposes only. It is not legal, financial, or insurance advice. Coverage and liability depend on the facts, the policy, the debris source, and the applicable law. If you have a real situation, speak with a qualified professional. If space debris hit your house tomorrow, where do you think you would start? Drop your answer below. And if you have ever heard of a stranger who pays situation than this one, I want to know about it.